And then finally, we have Caroline Ncube, who is a professor at the University of Cape Town, where I believe she holds the Saatchi Research Chair in Intellectual Property Innovation and Development. So thank you all for taking the time out of your busy schedules to be here with us today. We really do appreciate it, and we look forward to your contributions. So then that leaves me with sort of one last thing that I want to do before I get off the stage, and that is to provide just a quick overview of the types of things we will be chatting about today. So first, Kholo will set the scene for us by speaking on the background to the proposed TRIPS waiver. In doing so, she will touch on the TRIPS regime more broadly, as well as take a brief look at the history of waivers at the WTO. Next, we'll have Rafia, who will sort of myth bust the proposed TRIPS waiver, if you will, speaking to what it would and would not do if it were to come to fruition. And then finally, Caroline will take a look at South Africa's domestic legislation and speak to what can or cannot be achieved with and without a TRIPS waiver. So I think at this point I've said quite enough, so I'm going to hand over to Kholo to kick us off. Kholo?
Thank you very much, Alex. Good afternoon, everyone. And as Alex has said, my name is Kholofelo Kugler, and I'd like to express my deepest gratitude to the Mandela Institute and to the Health Justice Initiative for organizing this webinar. And I truly look forward to exchanging views with you on this topic. As Alex has said, my presentation will focus on the legal framework of the WTO that underpins this proposed waiver. Concretely, I will focus on the provisions in the agreement on trade-related aspects of international property rights, or the TRIPS agreement, and also the rules related to waivers under the Marrakesh Agreement establishing the World Trade Organization, which is the WTO agreement. And I hope that this understanding of the broader and relevant rules will be useful to you in understanding the broader issues of this waiver, especially in the context of which Rafia and Caroline will expound upon in a few minutes. So for those who are, TRIPS or trade buffs, sorry to bore you for the next 15 to 20 minutes. Feel free to take a walk or to grab some coffee. But before I delve into the legal provisions, I'd like to give you some background on the waiver so you know exactly, the content and sort of what's been happening since the waiver was proposed on the 2nd of October 2020. So basically, this is a proposal that was tabled by India and South Africa, and they submitted a document called Waiver from Certain Provisions for the TRIPS Agreement for the Prevention, Containment, and Treatment of COVID-19 to the TRIPS Council for approval. And this waiver has subsequently been supported by many, many countries, including many African countries, the LDC Group, Pakistan, the Maldives, Fiji, Vanuatu, Indonesia, and Jordan more recently. And when this waiver was proposed, or when it was tabled back in October, many primarily developed countries opposed the waiver. But in an about turn in early May 2021, the United States indicated that it was willing to negotiate a text. And this text is currently being negotiated. The EU and members like Germany have come out strongly against the waiver. And in fact, they have tabled a proposal as to how they envision, this whole, COVID-19 IP rights and, vaccine issues will be handled. The COVID waiver itself, the original one that was proposed in October 2020 was revised in May 2021. And I will expound upon the contents a little bit. But let me just sort of touch upon the EU's proposal, which is basically show that there's two documents that are being negotiated simultaneously right now in the TRIPS committee. So the EU basically has drafted a draft proposal for the General Council in which it calls for the limitation of export restrictions, supporting the expansion of vaccine production, and facilitating the use of current compulsory licensing provisions in the TRIPS agreement, basically stating that it has to be clarified that members do not have to negotiate with manufacturers or with IP right holders to produce any parts, of the COVID-19 essential products and essential medicines. And as I said to you, these negotiations are held under the auspices of the TRIPS committee. There have been many, many formal and informal meetings that have been held with regular updates in the General Assembly as well. Right now, the last meeting was in July, and the next formal TRIPS meeting has been scheduled for the 13th or 14th of October 2021. Now, what exactly is this waiver contain? And as I said to you, it was initially tabled in October 2020. It was revised in 2021, a little bit of a tweak. So basically, the co-sponsors are concerned that patents and other intellectual property rights could hinder the ability of countries that have very little or no manufacturing capacity to access COVID-19 related medical and pharmaceutical products. So this is not only, contrary to what everybody believes, it's not only about vaccines, right? I mean, vaccines is, of course, a very important and central part of the debate, but it also includes diagnostic kits, medical masks, PPEs, ventilators, et cetera, et cetera. So any, pharmaceutical or any medical product that goes to treating COVID-19. So specifically, the concern here of the members is that they will not be able to avail themselves to the flexibilities under the TRIPS agreement, or they will face lengthy approval processes obtaining pharmaceutical products under Article 21 bis of the TRIPS agreement. And I'll talk to you sort of in more detail about these specific provisions. And so what is the content of exactly what are they asking? So they're asking the General Council to approve a 3-year waiver from the implementation, application, and enforcement of copyrights, of industrial design rights, of patents, of trade secrets in the TRIPS agreement. And they will also basically request that there would be a peace clause, meaning that no litigation can be brought against any country that triggers these, these exceptions or exemptions. And also, this waiver will not affect the rights that LDCs have. And I'll go into a little bit of detail of the LDC regime, but just to sort of sum it up, LDCs, are exempted from protecting any type of IP rights, including medical or pharmaceutical products. And there's different type of regimes, but there's also a specific public health or pharmaceutical product regime, which will last until 2033. And basically, this waiver would be subject to the rules underpinning the waiver processes in WTO law and Article 9 of the WTO agreement, which basically, after the 3-year waiver, then the General Council will review the waiver every year. And as long as there are exceptional circumstances that justify the waiver, this waiver will be renewed annually. So this is just sort of the big picture background and the details of what exactly it is that South Africa, India, and the other co-sponsors are requesting from the General Council of the WTO. So now I'll just talk about the legal regime under the TRIPS agreement. So as you more or less know, the TRIPS agreement states that members must grant patent protection for 20 years. So, I mean, as I said to you, this is not just pharmaceutical products. We're talking about everything that can be patented. This is what is under the TRIPS agreement. However, there are certain limited exceptions to granting patent protection, and one of those fall under Article 31 of this agreement, which basically talks about compulsory licenses. And Article 31 of the TRIPS agreement basically opens as follows, and this is actually sort of relevant to what Caroline will be talking to us about, where the laws of a member allows, so this has to be sort of allowed in the domestic legislation of a member, a WTO member, a third party authorized by the WTO member, can use compulsory licenses to access the subject matter of a patent, so anything that is patentable. And compulsory licenses may only be used in situations of national emergency or other circumstances of extreme urgency. So obviously, the COVID-19 pandemic would fall under these categories. And so, specifically in the context of public health, a member may use the authorized use of the compulsory license to enable a generic pharmaceutical producer to manufacture one of the necessary medical products, subject to certain conditions, including the scope, the duration, and the purpose of this authorization. Now, there's many sort of subparagraphs and conditions that are, covering or that apply to these compulsory licensing. But I'm just going to discuss two because they're relevant to the legislative or the sort of regulatory change that happened from Article 31 to what we have now under Article 31 bis of the TRIPS agreement and also the annex of the TRIPS agreement. So basically Article 31F of the TRIPS agreement says that the compulsory licenses must be authorized predominantly for the supply of the domestic market. So obviously this is a problem for those countries that do not have any or very little domestic pharmaceutical or whatever product production, and they have to rely on imports. And another one is Article 31H that requires that the right holder must be paid adequate remuneration, but there's no elaboration of what this adequate remuneration is, but the right holder may review the adequacy that is determined by the WTO member that's issuing the compulsory license. So obviously this would be a problem for members that have financial constraints like many African and other developing countries. Now these constraints were raised by the African group in the late 1990s. And if you remember, this was the time when the HIV/AIDS pandemic was really at sort of the peak in Africa. And because Africa actually imports 94% of its medical and pharmaceutical products, African countries wanted to make sure that there was nothing that prevented them from issuing and compulsory licenses for imports, because they cannot produce enough domestically for their requirements. All of this led to the 2001 Doha Declaration on the TRIPS Agreement and Public Health. And then there was another decision called the Decision on the Implementation of Paragraph 6 of the Doha Declaration, which waived the obligations under Article 31F and H. And all of this went on to be incorporated into the TRIPS Agreement as it is right now under Article 31 bis and the annex. And this amendment of the TRIPS agreement is actually one of the only substantive amendments of the WTO agreement to date. Many countries have actually ratified the TRIPS agreement, but interestingly, many of them that have not, which is around 32, are African countries. And there's some Caribbean, Latin American, and Pacific states. So, I mean, what I'm trying to get at is there are flexibilities under the TRIPS agreement that allow members to derogate from the obligations to protect IPRs under the TRIPS agreement. And there's also a system that members can use to trigger this importation flexibility, which, the paragraph 6 system, which basically there has to be notifications by both the exporter and the importer to the TRIPS Council. You have to name and specify the quantities that will be imported, exported. You have to establish that there's no sufficient domestic production for whatever product that's been imported. And members must make sure that the compulsory license is granted in a TRIPS compliant manner. So, I mean, this system is very elaborate. It exists. It's for transparency, obviously, but there have been some difficulties in using the system because it was deemed to be onerous and inefficient. And in fact, the only country that has used it from beginning to end to date is Rwanda, when it was importing antiretrovirals back in 2004, 2007. It took that long. And more recently, we've had Bolivia and Antigua and Barbuda in 2021, a few months ago, triggered this mechanism as well. So it'd be very interesting to see, how quickly Antigua and Bolivia are able to access the TRIPS vaccine. So this was triggered for TRIPS vaccines. So just to cover quickly the waiver processes before I hand over to Rafia. So as you all know, this waiver proposal is supposed to be a waiver, which would be waiving obviously certain rights, particularly IP rights under the WTO law. And this waiver processes, or the rules of the waiver, are governed by Articles 9, 3, and 9 of the Marrakesh Agreement, WTO agreement. So basically the steps that have happened and that must happen are as follows. The waiver agreement was tabled, as I said to you, on the 2nd of October 2020 to the TRIPS Council. According to the law, members are supposed to consider it for a period not exceeding 90 days. Obviously, now we're sitting in August 2021. This 90 days have been exceeded. But obviously, this waiver has not been passed, so it's still being considered. And at the end of the consideration period, the TRIPS Council will submit a report to the General Council, either requesting the adoption of the waiver or detailing the progress. So right now we're in the progress. So as I explained to you, every so often, the progress reports to the General Council, or it will also be the Ministerial Conference as well. So once the TRIPS Council recommends the approval of the waiver by consensus, so meaning that all WTO members have to agree, the waiver will be adopted, and there has to be exceptional circumstances justifying the decision. And also you have to note the terms and the conditions governing the application of the measure, and also the dates of the termination of the waiver. And as I said to you, this waiver will be reviewed annually by the General Council. And if there's still exceptional circumstances that justify, the keeping of the waiver, it will be held. And so basically this is it. So although the WTO agreement contemplates a voting process whereby a vote can be taken by 3/4 of members to adopt a waiver, this has not been done much in practice. There is practice, but very limited in instances where WTO members have voted for waivers, and this includes the accession of Ecuador in 1995, and also for waivers for a few members under Article 2 of the GATT, which is basically talking about tariffs. So these members had to sort of adjust their HA systems into the new system. Not getting into the technicalities, was a very limited scope of what was required to do, and that's when voting happened. And obviously, as the practice is that members do not typically vote, and this waiver is quite controversial, it is very unlikely that the voting mechanisms would be triggered. And so this concludes my interventions. I'd be happy to sort of go back to anything and answer any questions. So Rafia, I turn the floor over to you.
Good afternoon, everyone. I hope you can all see my presentation. My name is Rafia Akram. I'm an IP consultant to Health Justice Initiative, and I'm very grateful for everyone that's here. I know it's in the afternoon, so I'm hoping to have a good discussion around the TRIPS waiver. And I'd like to thank Kholofelo for setting the scene for me. So my task is really to look at the TRIPS waiver and the myth busting around it and what it would or would not do. Just as a firstly, of course, it's important to set the scene and say and put it to everyone that we are still in a pandemic, and I know that perhaps with the WTO going on, breaking off for the year, there is an impression that perhaps people in the global north feel that there isn't a pandemic anymore. Of course, they've had a higher rate of vaccinations and so forth, but even so, with the new variants that are continuously being created due to not enough vaccines for the whole world, death and illness are still on the rise. The South Africa-India waiver, as Kholofelo alluded to, is now co-sponsored by around 63 countries and another 100 that support it. It specifically talks of waiving intellectual property obligations under Section 1, 4, 5, and 7, which of course relate to patents, copyright and related rights, industrial design, and protection of undisclosed information. The reason for that is that it is quite a wide waiver dealing with both diagnostic, therapeutics, vaccines, medical devices, and personal protective equipment. I think one could be a little bit mistaken with all the conversations having around it, that it seems to be focused on patents, especially with the United States on May 5th coming in support of the TRIPS waiver, only talking about patents. The idea is that, of course, it'll be for 3 years for review after that. And to me, what is quite an interesting thing is to allow countries to have respite from possible dispute resolution mechanism. Now, there are a certain number of myths that have grown around it, and a lot of it has to do with the discourse from the different entities. You have, of course, various actors that are fairly interested in the TRIPS waiver, not just states themselves, but also there are pharmaceutical interests that are involved. There are country economies that are at risk. And I think the latest information this morning that really gave me pause to think was that BioNTech on its own has raised Germany's GDP by 0.5%. It has raised a whole country's GDP, and solely based on what they earn from the current vaccine, as one part of a group, BioNTech, Pfizer, of course. Be it as may, sorry about that separate thing. It's just something that's been weighing on my mind. Compulsory licensing as found under 31 bis, and thank you for Kholofelo for just setting the scene between 31F and bis. The first myth is that it is fit for purpose in the form that it is. And the reason I say that this is a myth that exists is that it has only been used once. As Kholofelo talked about, Rwanda applied for a waiver under 31 bis for ARVs that were going to be produced in Canada and then imported into Rwanda for giving out to their population who were being affected by HIV/AIDS. It took up to 3 years for that to happen, and at some point I think Médecins Sans Frontières had to intervene and bring in medications from India. And the reason why 31 bis is fit for a purpose is a myth, is that countries that have changed their internal laws or want to change internal laws have been under severe political and economic pressure. And that includes South Africa, when we wanted to change our laws to allow for, generic ARVs to be brought in. And that political pressure comes in as, for example, Section 301 of the United States, which then investigates that country and for possible increase of tariffs. And there are similar provisions under the EU as well. Currently, of course, Beyleveld was a Canadian company, together with Bolivia, have applied for a waiver for IP that is being held by Johnson & Johnson. We are still awaiting what would happen there, because Canada, though it has those internal laws allowing for compulsory licenses, Canada has not made a decision. And of course, the EU's shadow proposal that again Kholofelo referred to, in it, the heart of it rests on the fact that compulsory license is a perfect mechanism. All of these things makes us, sort of question whether it's fit of purpose. The shadow proposal, as it is, of course, puts it forward as that, but the actual real life examples do not hold up that idea that compulsory license is fit for purpose. The other myth, which may be seen as a very positive idea, this idea that this TRIPS waiver will resolve all of the IP issues. Of course, that is untrue. In fact, the proponents themselves, through various engagement at the TRIPS Council and outside of it, have been trying very hard to make clear that they do not think that it would be resolving all of the IP issues. The idea is to take away a layer of constraint that exists at the international level, as well as limit limit international dispute resolution. And I think it's very important to realize that that is a very real threat that countries do worry about. The third, I think, myth that to me is quite an important one is that this waiver will stifle innovation. Pharmaceutical companies will limit research and development, that they will step back and say, well, this is not worth it if we cannot make money off whatever it is that we are putting a lot of effort into. What's the point? We have shareholders to respond to. There are two parts to this. Firstly, especially with this pandemic that we are facing, most of the monies for the research actually came from states, from philanthropic groups, and pharmaceutical companies benefited from licenses on IP that was actually researched at state institutions and then given to them. And I'm particularly talking about the mRNA IP rights. That is actually was researched and is held by the United States government. Also, secondly, R&D in general, which takes a lot of work. It happens at publicly funded universities and institutions. And I think, and I haven't really put it down, but it is very important to realize that already, just from what the pharmaceutical companies are sharing with their shareholders and so forth, they have made substantial profits from the vaccines that they have created. I mean, we're talking, of course, of the 7 newly minted billionaires. We're talking about, I think it's something, BioNTech, for example, is contributing 15 billion to the GDP of Germany. There are things, however, that a waiver will not immediately do, and we have to be quite honest about the impact of this specific waiver. That the first thing is that it will not ensure that pharmaceutical companies will share their IP. It rests in private hands or is licensed to them. And we know this simply because whatever contracts they've entered into to sell vaccine to countries, or the fill and finish contracts that they have entered into, J&J with Aspen in South Africa, Pfizer and BioNTech with BioVac, or the Serum Institute contracts, there is very little information sharing. And the reason for that, of course, is that, you know, they really rely on the opaque nature of their contracts to protect their IP, not just, of course, the patents, the copyright, but also the trade secrets. And the WHO set up CTAP, as well as the WHO mRNA hub, both of which were there to encourage voluntary sharing of knowledge by pharmaceutical companies of patents. They have not been used. The second thing that will definitely not happen, they will not, you know, the idea that there will be an immediate increase in supplies of vaccines, there are many other issues that come in to hamper vaccine availability. Even if there is a waiver, even if you have, because of the waiver, a lot of more compulsory licenses being issued, we would have to get, you know, pharmaceutical industries in low and middle income countries to that level to start producing these, and there will need to be quite a lot of knowledge sharing, which would require a lot of economic and political pressure. Even then, of course, that will take around 6 months just to get sort of the physical structures in place, and of course there are other blockages and so forth. So there are a lot of other things that come into play. And a waiver, you know, the idea that it would allow for this compulsory licenses to be issued, and then I don't want to step on what Caroline will say, but just as a thing, we do need a state 31 bis requires that you do have 31F required, and that you do have legislation that allows the issuance of compulsory license, whether it is for imported things or for production internally. South Africa is still reviewing the copyright amendment bill and has not yet tabled the patent amendment bill. Other countries very quickly in 2020 already made changes to their laws, amongst them to allow for compulsory licenses for increase sharing information and so forth. And I know currently there is another policy before the EU talking about internal sharing of information on where there's a medical need. So the countries that made recent changes, Germany, Canada, Chile, and Israel, to allow for easier sharing of pharmaceutical information. What a waiver will do, though, is also important to realize. So we're not in a pessimistic mood. It will, I think it would allow for a lot. The first is that it creates an incredible window of opportunity. It allows for compulsory licenses. Once you have the internal laws in place, it allows compulsory licenses to be used. And it is wide enough to not just focus on vaccines only. It talks to therapeutics and medication and medical equipment and PPE. Because of course, as we learn about this virus more and more, we realize vaccines are not going to be that savior that's going to get rid of this COVID-19. We do need people might still be hospitalized, will need therapeutics, will need equipment to help them. So, it is a wide enough thing that would cover all of these. It also creates this opportunity for us to internally agitate and ask for laws that balance the right to property versus the right to health. In South Africa, when we are still sort of grappling with getting the Copyright Amendment Bill through and talking about the patents, we should be making sure that those balances, as required by our Constitution, are explicit. And they are explicit in a sense that covers this kind of thing, because we will have this, not only this pandemic, but future pandemics as well. There is also a developmental a focus on the sustainable development goals to looking at the issues around inequality and economic development. And I think that is another thing there are lots of things that COVID-19 and our response as humanity to it has really laid bare, and that is the inequality in so many ways, and in terms of how governments deal with it, how people are taken care of, how the economy is still propped up, and specifically the vaccines and the patents and the access to healthcare. And it really focuses our attention on those. And the one thing that I think is quite important is states can feel capable of doing all of this thing without that fear of dispute resolution. Arbitration, international arbitration specifically, or litigation at the WTO for low and middle income countries is a very fearful thing. It is costly. It can not just if you lose, even if you win, it is still costly. So it's something that sort of relieves that pressure. And I think the fifth thing, which is a very soft thing, but it is important, it would lessen the political pressure. It would make the threat of being put onto the Section 301 seem unethical, and then you would have certain countries sort of holding back on that political pressure, which would be quite interesting to see how many compulsory license mechanisms are then set up in internal laws because of that. There are other possibilities that have cropped up, and I think this comes from what I am incredibly bolstered by in my research and my work, and that is that we are starting to really go down to the nitty-gritty on a lot of things, that we're looking with very carefully at how R&D occurs in the development of medical technologies and medicines and vaccines. We're starting to question how pharmaceutical companies do their research on the different continents, what precautions. We're looking at all of those sort of things and seeing how that research, where it is being done and how it's been done and who is being involved. We also have a greater interest now looking at the financial side of things and looking at funding models and how the pricing on medicines is occurring. And You know, in the United States, there's now big questions around, you know, how the insulin pricing is taking place and how it's been increased in a lot of medicines. And those are the same kind of discussions I hope will flow through in our you know, sort of policy institutes and government and so forth. A very important and I think essential discussion is to really look at healthcare and decide, especially as we go forth in the national health and NHI in South Africa, national health insurance, is to look at where health and the IP that rests in all of these things, where does it, you know, to what extent do we put things in the public good basket versus private ownership, and how do we balance those rights? And also, and finally, and this is not a closed list, and I'm hoping people will tell me more if they have greater insight. I think there are a lot of more questions, perhaps not as many answers, but questions on how pharma chooses to focus on some diseases only. There is, you know, certain diseases get a lot more money, they get much more attention, there's a lot more research happening. Other diseases, especially those that are found in the global south or those that are rare, there's a far less focus and on that, and there's a choice that is being made, and how and we are starting to question how those choices are being made. So to me, the TRIPS waiver has there's a lot of, you know, sort of almost positives in it. I think it may, in some people's mind, you know, might be doing too little or too much. And I think it's about being very honest about what it can achieve. But I do appreciate, even while it has not yet gone through, and then there are questions around that. And they will be voted frequently during when WTO was GATT, and we have lost that practice now in WTO. I'm hoping that it will go through quite seriously, because I think it will be an essential victory really for the global south and low and middle income countries. It will change how we view healthcare, and it would be a step forward. In the meanwhile, I'm just grateful for all the discussions that we are having, and you know, discussions such as this. So I'd like to thank everyone for listening to me ramble on. And I look forward to the questions and the discussions that follows. I hand over to Professor Caroline Ncube.
Caroline, we can't hear you.
Really?
Now we can, yeah.
Okay.
Yeah.
Good afternoon, everybody. Very pleased.
Sorry, Caroline, I think you're still a bit
really?
Still a bit quiet. I'm struggling.
Okay.
I don't know if it's just me, but I'm struggling to hear you.
This normally happens to me when I'm working on Teams on my desktop. I might have to change to my laptop. Is it any better now?
I can hear you. So yes, it is.
Better. Okay. If it persists, I will have to change.
Okay.
So good afternoon again. Thank you to the organizers of this webinar, and thank you to everyone for coming out. This is a really exciting moment, I think, for all of us. And I like how Kholo and Rafia have really set this out. So they've done a lot of the background work for me. I'm just going to leverage off most of what they have said. Like a good lawyer, I'm going to start with some caveats, and these would be the following. I'm really going to be putting a lot of ideas on the table. I'm hoping that we're going to, as a group, use the discussion time allocated in this webinar to actually thrash some of these things out and think through them together. So it's more like the start of a brainstorming session, if you like. That's what I've told myself I'm going to be doing. So I'm really going to be building up on what already has been done. You know, we've all spoken about, Kholo has taken us through the background, where we are in terms of the waiver. Rafia has been really good in giving us a reality check in terms of what can be achieved, but she's also held out a lot of promise, which I think we should grab onto, because there is promise and opportunity that will avail itself if this waiver goes through. And I also think that even if it doesn't go through, the very fact that we are engaging with it opens other windows of promise, of opportunity that we should grab. And when I say we, I'm speaking, as you will, for states. And because we're sitting here together in South Africa, thinking about South Africa, I'm really thinking about South Africa and what can be done in this domestic space. Then the other thing that I wanted to say by way of kind of framing and groundwork would be this bit that I'm leading everybody into, the brainstorm, so to speak, will be to speak very particularly about what can be done with domestic laws, domestic IP laws. But it is by no means an attempt to draft an amendment or to think very carefully and technically about how to actually draft these amendments. What I'm really wanting to do is to lay on the table the kinds of issues that should be considered, and then of course much more thought and technical precision needs to be applied to actually thinking about the actual wording or phraseology of the amendments themselves. So I could tell you, in a sentence, what I'm going to be suggesting, and it's the last two bullets on the slide. That is to say that without the waiver, still IP law amendments would have to happen. So I think the difference for me is what the country would be working with and what the basis would be. So if the waiver does pass, then of course that would be the basis for further domestic action. If it doesn't pass, then still there is necessity, urgent necessity, if I may add, for actually taking domestic action. And I also think it's important that having led on the global plane to support, to sponsor the waiver, that actually South Africa also needs to lead nationally to show its commitment to this proposal. So I think that there should be activity on both ends of the spectrum, particularly so in the case of South Africa as a co-sponsor of the waiver proposal. Okay, so the fundamentals then, we've been taken through the fundamentals. I don't need to linger here. The only thing I wanted to reiterate that has been said by the other two before me is that sometimes talk does get corralled into patents only and vaccines only, and that's not what the waiver is about. It's much broader than that. It's other IP rights, envisaging copyright, designs, and trade secrets specifically mentioned in the proposal. And then it's much more than the vaccines. It's all of these other things. So just to keep that in mind. And that's important to keep in mind at the start of a brainstorm regarding domestic action, because that means that the domestic action that we're thinking about is more comprehensive. It's wider than just patents, wider than just vaccines. So Rafia has also spoken about this as well. Let's say that the waiver did pass. What would its main benefits be? It would be opening up that window of opportunity, but also removing a lot of the vulnerability that developing countries actually have in navigating trade laws internationally. So this ever-present threat of perhaps having been hauled before the DSB, the dispute settlement body, is actually quite unnerving and actually quite unaffordable for many developing countries. And as you just heard, even if you win, you will have lost. It comes at a great cost. And so should the waiver pass, it at least takes away that vulnerability. It also takes away exposure from individual nations who go out, because there are other means or mechanisms that are used to perhaps keep states in line. And so if there was a mass movement, a mass adoption of the waiver, then no states are vulnerable and are out there exposed. So that would be good. It would also lessen the reliance on existing mechanisms. They are there, but we know that they haven't served South Africa and many other countries well for a variety of reasons. And I looked at the list of participants, and I was very happy to see a number of colleagues and friends. And so I know that in the audience, we've got Chikosa Banda, who has written a lot about the shortcomings of the existing mechanisms that we have. I've heard him speak often about how states have not actually used the flexibilities that are available. I listened to him quite recently on that very point. And so the waiver would help in that states would then not need to continue relying on these mechanisms that we know have not served them to the full extent. And so later on in the brainstorm, I'm hoping that Chikosa will stay around for the duration and perhaps he will have some ideas to share with us. Okay, so having kind of framed it in that way, I would like to proceed then to do this, to talk about what would be necessary on the domestic plane, speaking particularly about South Africa, but I do know that there are friends and colleagues in the audience from other jurisdictions, and so obviously what I'm saying about South Africa, you can obviously be thinking about that in terms of other jurisdictions, the Global South, developing countries that might apply to you. So implementing a waiver it's not unknown, right? So there have been waivers before granted under the TRIPS agreement that have been implemented. So I'm just going to use the TRIPS amendment and the history of it, right? So we started with the Doha Declaration in 2001, which then became a waiver decision in 2003, and eventually became the TRIPS amendment in 2005, which has now come into force with effect from the 23rd of January, but only for those countries who had, of course, accepted the waiver. It remains open for acceptance until the 31st of December. So that's broad strokes. But what I want to light on is the fact that after the waiver decision in 2003, some countries already implemented it, and these are the lessons that I am wanting on. And I'll try and explain why I think those lessons are important. So Norway, as an example, actually implemented the 2003 waiver almost immediately. In 2004, I made a mistake there on my slide. I wrote 2014. That's incorrect. It's 2004. So this is just a timeline. So we know that the waiver, we can start with at 2003 up to the present. We know that it's in force for some. It's relevant for South Africa because South Africa has actually accepted the waiver. So what did Norway do in 2004? In 2004 already, Norway implemented the 2003 waiver. And this is their notification document that they sent through as required to TRIPS Council. I just copied and pasted it. So you will see even in their labeling of it that they called it the implementation of paragraph 6 of the Doha Declaration. So the lesson, I suppose, for us is that should the waiver pass, it can and should be implemented most immediately. But before I tell you the notes from Norway, I just took another screen grab of that notification document to show you exactly what they did. This slide, of course, has a lot of text because it's their actual document. What is important, I've put little flags next to it in blue. So what is important is to see that they amended their Patents Act in order to allow for compulsory licenses. They also then amended their supporting regulations so that this works. And then the third thing that they did was, of course, to make the necessary notification in terms of the TRIPS agreement. So it is possible, it has been done. And the way is that should the waiver pass, it will be possible to implement it straight away, much the same way that Norway has done. And this would be done through domestic legislation and supporting regulations if needed. And then, of course, the necessary TRIPS Council notification would have to be made. So still then talking in this domain of if it passes, should it pass? The second part of my talk will be if it doesn't pass, what do we do? So I'm still with the first one. So let's say that it passes, what then should happen? South Africa would follow the example of Norway by making the necessary domestic enactments that would be required. This would be to amend the relevant IP legislation. South Africa has done this before. So after the country became bound by the TRIPS agreement, we had an IP Laws Amendment Act 38 of 1997, which amended a whole slew of IP statutes in order to bring them into alignment with the TRIPS agreement. So I would suggest that the most effective and most efficient way to deal with the national provisions, should the waiver pass, would be to pass another IP Laws Amendment Act that deals with all of the necessary amendments in one fell swoop, so to speak. It would be very carefully and precisely drafted to make sure that it complies with the waiver decision, that it's crafted appropriately so that it kicks in for the duration of the waiver and does precisely what is required by the waiver. So this slide then just throws out some ideas about what may go into that IP Amendment Act. So we would obviously have a preamble that frames the legislation. Okay, I was pausing a bit. I thought perhaps someone wanted to speak. We'd have a preamble that frames the amendments to tell us that they are, of course, in the context of the pandemic, that they're flowing from the TRIPS waiver that has been passed, and then we would step then to the rest of the bullet points here to actually do what would actually have been decided in the waiver as it comes out at the end, right? So now we're sitting with a proposal that has been revised, and if it goes through to further text-based negotiations, you know, we might end up with some different wording, who knows? But the idea is that whatever that final adopted wording would then be translated into the domestic plane. What I do have on this slide by way of example would be provisions based on the current revised proposal that is pending further discussion and negotiation. So currently we would be talking in terms of the waiver proposal of suspending the operation of some provisions relating to patents, to copyright, and to designs for 3 years for the duration of the pandemic. And so you could speak about the details, other details that we might want to consider if we got to that stage would be, what about patents that are actually applications that are pending, that are in the system? What happens to them? The answer again is we've been here before, right? A mailbox system has been previously used under TRIPS whilst we were in transitional periods. And so that could be the same again. Pending applications could simply be placed metaphorically in a mailbox, suspended, so to speak, and then they would be revived after the duration of the suspension. Right? So that's one possibility to deal with this. I'm sure there are other possibilities, and that perhaps some people will share this in the discussion when we come to it. Then when it comes to undisclosed information, this is trade secrets. In South Africa, we don't actually have express data exclusivity laws that deal with this, but frequently people just, companies or applicants for regulatory approvals just rely on confidential information, trade secrets. All I wanted to remind us of is that, of course, in TRIPS Article 39.3, there is the exception that would be invoked should the, and it can be invoked anyway. Right now, it's not dependent on the waiver, right? It's sitting right there in the TRIPS agreement. It could be used. So I wanted to focus on patents. So we would be thinking about an IP Laws Amendment Act that pertains to different IP statutes. So copyright, designs, we don't have, you know, undisclosed information is dealt with under the common law. So we would be looking at patents, copyright, and designs. But for the duration of this talk, I'm really going to limit myself to patents. And the reason for that is because they have a very significant impact on what's going on. And this is just an image that I like to refer to frequently. It just shows all of the different stages where patents are actually an issue, not may become an issue, are an issue in the vaccine development process. So they're very significant. That is not to say that designs are not important. They are very important. The Copyright Amendment Bill is currently under consideration. It's really important to the extent that we need updated current research exceptions, because this would be necessary to enable, to facilitate, to support all of the research that is going towards vaccine development, diagnostics, and everything else that is required at the moment. But I'm just going to focus on patents for now. So what then would we do about patents? Well, you know, I keep on saying we've been here before. So last night when I was preparing for this, you know, when I started, I felt like everything was terra nullius. We were new ground. We didn't know what we're doing. But the more I thought about it, I thought, but a lot of the groundwork has already been laid. A lot of the work has been done. So I think what is required really is momentum. And in the context of patent reform, we have an IP policy, right, from 2018 that was adopted by Cabinet, that was in the works for a very long time. There's been a lot of activism and momentum, starting and stopping about actually getting these reforms done. And so a lot of the work is done. If this is a screen grab again from the policy that shows you the kind of thinking that has gone in here and what the government actually has committed themselves to. And I look at it and I think if only this would be implemented, if only the Patents Amendment Bill would see the light of day, then we'd get moving. And that can happen without the waiver, and it should. And so let's say that the waiver does pass and is adopted. I would say that we would require an IP Laws Amendment Act that deals with all of those issues, suspension or whatever the eventual final decision would be in relation to the waiver. But we also do need to get all of the recommendations in the IP policy actually taken care of. That needs to be done. It's long overdue and it will assist us in a number of ways. And I also think that it makes sense to also go ahead with the patent reform and other reforms beyond that, because it will allow South Africa and whichever other state is considering this to actually add other elements that are perhaps not covered by the waiver or not dealt with, or just to enhance the approach and to make sure that it is comprehensive and thorough. And also, of course, we can't hang everything on the waiver because the waiver is time bound. It is initially, as Kholofelo explained, intended or proposed to be for 3 years, and then it might be extended as and when the need arises. So if we have this IP Laws Amendment Act that makes these amendments, they would be time bound to the duration of the waiver decision, and then they would fall away. This is why they need to be coupled with established durable reform in the Patents Amendment Act anyway, that will not be dependent on the duration of the waiver. So if we look then at the IP policy and what is suggested there, and how would it help us then with dealing with the pandemic, I think it would do a lot. So there are certain suggestions. I've picked a few of them. I can't really speak to them in detail because of time constraints. But if South Africa were to follow on the promise of the IP policy phase 1, to introduce strict patentability criteria, to introduce phased substantive patent examination, all of that would be really useful. It would help when it comes to vaccine and vaccine technologies and all of the other health care requirements that we have relating to the pandemic as it faces us. And the thing also about seeking durable solutions is that perhaps this is the most recent pandemic that the globe has been faced with, but it is by no means the first, and it is by no means the last, unfortunately. So that's why we would need long-lasting, durable solutions. The IP policy also suggests that there should be the introduction of robust pre- and post-grant opposition procedures. These currently do not exist under South African law, and this will just help to strengthen the system to enable third parties, knowledgeable third parties, to come in and share objections and information with the CIPC, the Companies and IP Commission. Then the improved issuance of compulsory licensing. Here I'm thinking a bit about what Rafia said, and also Kholofelo spoke about this already. The IP policy addresses compulsory licensing along these lines. It says that the country's got provisions already, but that the provisions are unwieldy in the sense that they hang on litigation. You've got to apply to the Commission of Patents, and that is a High Court judge. And so the IP policy suggests that a less wieldy process be introduced that won't take as long, that won't be as expensive. And I think that that is a very credible, very strong proposal that should be taken forward. And then there is also discussion in the IP policy about increasing transparency of patent office filings, and also that would be very important in shining a light on the IP landscape so that the role players actually know what different IP rights are in play with regard to various technologies, and it just makes it easier I would think, to innovate in this space and to move forward quickly. Other things that I've read about, maybe some in the audience, in the room, might want to talk a bit about this, who've thought very deeply about this, but I came across a paper by Fred Abbott that he wrote last year, where he suggested that Article 73 of TRIPS should actually be used by states to take action. So he's suggesting that even without the waiver, certain action can be taken to suspend intellectual property rights in terms of the security exception. And as I read his paper, if I understand it correctly, he has emphasized paragraph B, that a member would be able to take action that it considers necessary for protection of essential security interests. And he argues that this current pandemic actually is an emergency in international relations. So he makes this case in his paper for the use of this provision. The paper also highlights the fact that he thinks there's a strong case internationally to rely on this article, but he clearly acknowledges that there would be challenges on the national or domestic plane with regard to this. And so once again, I'm just putting it on the table. I wonder if someone else has read this paper and if they have thoughts and opinions on that. And so this really is kind of the end of my opening gambit, if you like, to this brainstorm that I'm so looking forward to. So I think without a waiver, with the waiver, let's start with the waiver. With the waiver, South Africa would have to take the necessary domestic action to make sure that relevant national provisions in IP laws are in place to make this happen. I've spoken about how it is at that stage then, once we have the final waiver text, that we can be technical and precise about the exact wording and how it is done. But I've already suggested that the most efficient way in my view to do this would be to pass an Omnibus IP Laws Amendment Act and put all of the amendments in one act, albeit amending the three different acts: the Copyright Act, the Patents Act, and the Designs Act. I've also said that I think that even if that is done, because it will be time bound to the duration of the waiver, I also strongly would recommend that the Patents Amendment Bill be tabled as soon as possible, taken forward, and to implement the policy decisions already made in the IP policy of 2018. Without a waiver, strongly think that South Africa should move. What is the metaphor? Put its money where its mouth is. What is it? I don't know. But because of its strong leadership at the global level and even on the continent at the AU level, I think it behoves South Africa to actually take strong and urgent national action, even without the waiver, to show its commitment, to show a coherence in its policy approaches, to back up the statements that it's making at continental level and at global level. So I would say, again, the country needs to move forward with the Patents Amendment Bill to implement the IP policy as adopted. I mentioned in passing earlier that we also, and Rafia made the same point, that we do need to see movement on the Copyright Amendment Bill to the extent that it facilitates research using modern technologies such as text and data mining. This will be important to facilitate and support the necessary research that we need in this area. And I can only end by saying, in view of the delays globally, breaks until I believe it's September, it does not look like a global solution is on the horizon. It does not seem like that to me. And so I think that national action is imperative at this stage. South Africa needs to take action right now without the waiver, and to do whatever else is needed later on should the waiver pass. And so that's my spill. References, I am sure that the organizers will circulate our slides to everyone who's in the room, so you can follow up on some of the readings should you be so inclined. Thank you very much.
Thank you very much, Caroline. That was really excellent. Thank you also, Rafia and Kolo, for your presentations. It leaves us with a lot to think about, I think. And there are some questions in the chat that I want to get to immediately. questions, and you know, whoever wants to have a stab at a particular question can just indicate on their cameras, and then we can go from there. Could we do that, perhaps? Okay, I think let's start then with, so I'm just going to go through the chat first, and then once we've gone through the chat questions, we can take a look at the hands that are being raised. So first in the chat, we have a question from Fran, and then she also asks a question later on, which sort of goes to this Article 73 issue that Caroline raised towards the end of her presentation. So Fran, I don't know if you want to ask your questions yourself. Would you like to take the floor?
I can, but I think that wouldn't be no way different than I asked the question. So I think Caroline has addressed it with 73, so that it is a possible option. And I was just wondering why South Africa, or other countries so badly want to do some actions, did not use it, and if anyone has some thoughts around it, to use the 73 despite diplomatic problems, of course. And then I had a question with regards to the General Council meeting that was supposed to be on the 27th, 28th July and give some further findings, and I couldn't find anything on it. And I just forgot to put my camera on. Sorry, you just said that. So yeah, hi. So yeah, that was it, just because I couldn't find anything.
Cool. I have not been able to find anything either. I see Rafia, I think, has a hand up. Rafia?
Yeah, I'm sure Kolo will also will agree to will give information about the 27th and 28th. I think at this point they haven't yet published it, but you know, there wasn't much movement other than just stating where things stood at that point. Some people are optimistic and others are not. And, you know, there are a lot of informal sort of information out there. I think Geneva Health Files is a good place to look at. With regards to Article 73, and I've had this discussion with a few people, the reason a lot of low and middle income countries are not even considering that is that Qatar has used it. So there has been use of it before. But that specific article does not take away the fear and the possibility of the dispute being taken to the DSB. And maybe a country like Qatar can afford going to the DSB, but a lot of the low and middle income countries do not have that.
So, I mean, I'm not going to say anything different from Rafia, but I just wanted to sort of scratch a little bit on 73. So, I mean, the issue of publication, as you know, it takes a while for WTO to load documents. So I just looked on the minutes right now, and I think they're at March in the TRIPS Council. And so it's going to take a lag for, for the official documents to come up. But on 73, I thought it very interesting that the specific provision that Rafia, talked about that was invoked by, Qatar, or actually Saudi Arabia in the Qatar-Saudi Arabia case, is that there must be an emergency in international relations, war or other emergency international relations. And when you look at the Ukraine-Russia panel, the panel in that case read that very narrowly to basically mean war or, something close to war. And so I wonder if we're at the point where we're anywhere close to war. I think it's a very interesting argument. And as Rafia said, I mean, as we know, the security exception is very difficult to invoke. It's very political. It's very newly litigated. There are many countries that do not want to litigate it, including the US. And so it would be interesting to see if this was ever used and how would would work out and how a panel would interpret that in the context of COVID. That's just my contribution. And if anybody wants to sort of get back, I'd be happy to hear it. Otherwise, we can leave it here.
Thanks, Kholo. Yeah, I think those are excellent points. The existing case law on security exceptions do suggest that we have to be closer to, like you said, or something a bit more warlike potentially. They did read it quite narrowly, but yeah, I think if ever there was an other emergency in international relations that was, you know, on a similar scale to war, one could conceivably think that a pandemic would qualify. But I think, you know, let's not dwell on that too much. Let's perhaps move on to the next set of questions. Jackie also had 2 questions, so I think, Jackie, do you want to ask your questions?
Great, thank you very much. This has been an extraordinarily amazing panel. Thank you to everybody. I just wanted to ask Rafia, I didn't quite understand the point you made that the TRIPS waiver proposal wouldn't resolve IP issues because these are held privately by pharma companies, etc. But wouldn't that be the whole point of TRIPS, that would bind the? I would have thought a waiver proposal would bind those private pharmaceutical companies. Maybe I'm totally wrong about that. And then the second question was, now that I understand for the first time that after a waiver proposal, assuming it was accepted, whether by consensus or voting, that then we would have to, in South Africa, change the legislation. That makes me think that we might be up to 3 years anyway, the kind of time that it takes for the, as I understand it now from this presentation, for, if I'm correct, the 31 bis procedure. So would there be a difference in terms of time? Thanks.
Rafia?
Should I go ahead? Yes. So the first thing is that what the waiver does, it takes away the international obligations, but all the rights that companies hold to their IP exist on the domestic.
Rafia? I think we've lost Rafia there. Yes. Does anyone else have? Anyone else want to step in there?
No, I just wanted to jump in because she's basically answered the question. Is that the TRIPS waiver would deal with international obligations, as she was saying, and then going into actual company-specific IP rights would have to come in at the domestic level, as Caroline was alluding to. And so it has to be sort of a 2-tier process where domestically countries have to obviously, legislate certain action that private companies have to act. And obviously then that would translate into the international sphere. As you know, private companies, well, I mean, I think the TRIPS is a little bit different than other agreements where it can be read that private companies have got rights under the TRIPS agreement, but generally the rights, and obligations are country rights or member rights and obligations, and individual persons or juristic persons would not have sort of direct rights and obligations under the TRIPS agreement. So sorry, Rafia, you go back and answer your own question.
Okay. Sorry, yeah, I have no idea what happened. Apologies. But I gather Kholofelo has done a decent job explaining how those IP rights are held at domestic level, and therefore you take away that international obligation, but nationally states protect the IP rights of these private companies, and they have to voluntarily decide to share that information. And voluntary does not, of course, mean that they don't get paid for it. I mean, that is beside the point. I mean, most of these contracts, if they do a compulsory license, there will be compensation. So that's, you know, that's taken out of the equation. So that's not an issue. So, you know, the companies still have to decide to do that. With compulsory license, what happens is that a state can force a company to share it, but you need to have that legislation internally to allow the state to intervene when there is an emergency and so forth. With regard to the other one, in terms of the time limits, if the TRIPS and you know, of course, you know, you'll have people who are for the TRIPS waiver and those who are against, coming up with different timelines. But as far as I know, from the kind of foresight, the sort of projections that people have done, it would take 6 months from the time that a TRIPS waiver is granted and legislation is passed in a country for all of the systems to go up and running in terms of the pharmaceutical side. Currently in South Africa, the issue we have is that we have legislation, bills that are going to Parliament, but there is a great level of opposition from parties like the DA, who want to protect property rights with not taking into account all the other sort of imperatives that we have. So what we need really is an understanding of what the country needs, and what not what our political affiliations are when it is a situation like this. And also that, of course, great understanding that compulsory licenses is not something that's going to be willy-nilly granted to companies. I mean, you know, we have our obligations internationally to do them in a very specific way, and to make sure that we protect people, you know, the IP rights. We have agreed to the TRIPS. So, you know, this sort of a little bit of fear mongering that comes in from the pharmaceutical companies as well, who are putting a lot of economic pressure, as well as internally the political pressure, is problematic. So I do think that the timeline would not be 3 years. And yes, there are the ARVs that finally ended up in Rwanda that came from India happened, but you know, if one just looks at what is happening to Beyleveld, it's been between 4 and 5 months that they have applied to the government of Canada to ask that they issue a compulsory license so that their process can start. That has not happened. In India, for example, we have a lot of generic producers, and a lot of them are asking the Indian government, who do have compulsory license legislation, to do the same. And you have all of this economic and political pressure from other countries like the United States and the EU, and countries are unwilling to grant it. And this TRIPS waiver also creates that political change. Thank you.
Thanks, Rafia. I think next, let's move on to Nazia. Nazia, you had 2 questions as well. Would you like to ask them?
Sure. I can't put my video on at the moment, but my name is Nazia. I'm a candidate attorney currently at Waiver. So I think my first question was kind of answered, with the fact that there'd still be domestic obligations. I think then in that way, there would still be the impact of, non-disclosure agreements and possibly restraints of trade. It wouldn't really be just a free fall. So we can move. I can then ask my second question then. I wanted to ask, so we've seen with other like medical devices and the like, where SAPRA needed to approve them, but they've expedited that in terms of regulations or policy, in terms of the Disaster Management Act. Would it be possible for something similar to happen with the waiver?
Who's going to take this one? Caroline, Rafia, do one of you want to take a stab at this one?
Alex, I missed the last bit. Sorry, I missed the last bit of the question.
Sorry, Nazia.
Sorry.
Did you just...
Sure. So I was saying that we've seen with medical devices and emergency medical equipment, such as, ventilators and oxygen tanks, things like that, that when it's been imported, instead of getting necessary regulation and approval, it's been expedited with regulations and policies that have been implemented in terms of the Disaster Management Act. And I was wondering if something similar would possibly happen in terms of IP law if we didn't wait for the implementation of entire acts, but the government instead just implemented regulations and policies in terms of the Disaster Management Act for IP-related aspects.
Okay, thank you. So I've heard Prof. Yusuf Fadwa actually speak about this at other webinars. I think the position is that it would be possible, but I think the experience that we've had in South Africa with the regulations under the National Disaster Management Act has shown us that even those regulations can be delayed through court opposition. They can be litigated on. So I think, yes, in principle, it can be done, but it would also be open to challenge. And so I think it is for that reason that the piece that I'm thinking about, Prof. Vadwa actually then said he thinks it might be better to have enabling legislation actually amended rather than to try and go by way of regulations, which will be challenged.
Great. Thank you. I think then next, let's time. So let's go perhaps next to Nicola.
Sure. Hi. Thanks so much to everyone, and everyone. I just had a quick question too. The first one is something I don't know a lot about. It's just the question of how a waiver would affect test data exclusivity, and if there would still have to be a period in which there would be test data exclusivity, and so that the generics wouldn't be able to be produced, or if that would also be included in the waiver, because from what I understand, it's a separate thing. And then the second was just is there a possibility that certain countries would be reluctant to issue compulsory licensing, or because of the fear of retaliation from some of the pharmaceuticals, so pulling out other products that they supply to the country because of that. Thank you.
Thanks, Nicola. I don't know who to throw this one at. Rafia, do you want to have a stab at this one?
The data exclusivity, and I think Caroline alluded to data mining as well. That's the Copyright Amendment Bill that's before Parliament currently. So that deals a lot with the kind of data that's generated when people get tested and all of that information. And so the current Copyright Amendment Bill would allow for that to be shared. So there's an exception there that's present, and that's, I think, is great. I think it is the Article 7 that deals with undisclosed information. That would cover, I think, test data subject to correction from either Kholo or Caroline. With regard to retaliation by pharmaceutical companies, remember when, there's quite a few of us that were around when South Africa tried, sort of changing its laws. We were sued by 39 companies. And also, of course, there were a lot of, sort of political pressure and so forth placed. They had to change their attitude rather. And that had really to do with the idea, I think, and an understanding globally of how unethical that behavior is. And I think even currently there's more and more deep understanding of how unethical this inequality is, and a reference to vaccine apartheid. So if companies and they would do that. I think they would bring that economic pressure and that healthcare pressure, lack of healthcare pressure. But I do think there will be a lot of pushback against them. I don't know how it would play out at the end, but I do think that similar to the HIV/AIDS ARV sort of thing, where companies were severely impacted when they misbehaved. It might be similar now.
Great. I hope that answers that question. Okay, I think next then we should give Charlene the floor. Charlene also had 2 questions, it looks like. Charlene, do you want to ask your questions?
Thank you very much. It's been a very enlightening discussion. I thoroughly enjoyed all the presentations. I think for me, the first question just has to do with, are there any incentives that can push pharmaceutical companies to start sharing? If the TRIPS waiver does not go through, is there a chance that maybe the threat of it could at least motivate them to share maybe it's vaccines or therapeutics with the developing world? And then this somebody, I think it's Jackie, has mentioned the pandemic treaty. I'm not too sure of the contents of it, but I was thinking, since when we had vaccines become available, the countries in the global north bought up pretty much all the stocks, and such behavior can then militate against developing countries. We can't get access to vaccines. So maybe if within the framework of the WTO or any other organization, there could be something that behavior or such practices, would it be possible? Thank you very much.
Thanks, Charlene. I think Rafia, I'm going to throw this one at you again. Do you have any ideas on these questions?
Yes. Firstly, I think the threat of the waiver has already had an impact. I mean, Aspen and you know, the J&J contract, which is now a little bit sort of has been widened to include other things, as well as the Pfizer-BioNTech BioVac contract. So, you know, you have all of these other things that are being thrown as sweeteners to almost stop the waiver discussions, which is a good thing. Of course, the point is for not to stop, not to step back and say, thank you very much, we'll take this, and that will be it. As to you know, sort of the hoarding and so forth, and this is where I think the whole movement around the TRIPS waiver has been amazing, because it's included academics, activists, and states such as South Africa and India, and all of that has coalesced to you know, action in developed countries, you know, people protesting there and things like that. So there's a lot of political pressure being put internally in those countries. You know, with the German Chancellor, when she went to visit President Biden, you know, there were activists outside of White House. So all of that is being done. How much we can force countries to share what they are holding? I mean, 210 million doses for England, many more everywhere else, I don't know. And this is just really as much about that constant interaction and working together. I'll leave, I stop there so that Caroline can also just add.
Thanks, Rafia. You know, as you were speaking, what occurred to me was that a lot of the research that has led to these health technologies that we are needing, that we're requiring for the pandemic, actually are publicly funded. If you follow the money, there's a lot of public funding. And so I think what this does then is open a window for states that have been providing the public funding to say, look, we carried you thus far, and if you're going to continue not to share and act in, you know, whatever undesirable ways, then the public funding is going to stop. So I think that that is a useful stick that some states need to actually wave around.
I see Kolo also has her hand up. Kolo?
No, I just very quickly wanted to add sort of the legal obligations, or, you know, rights under WTO law at least. Of course, there are requirements that states do not restrict exports under Article 11, for example, of the GATT. But equal to that, there's exceptions, right? There's exceptions under Article 11 itself. If it's, you know, if there's a foodstuff that's needed for the domestic market, and also, of course, under Article 20 of the GATT for reasons of public health, for reasons of complying with domestic regulations. And so, of course, I think broadly, there's been a conversation at the WTO itself about transparency as to what steps countries are taking to, to make sure that they have enough supply for their own domestic population. And of course, the questions are around is what is sufficient? I mean, do you really need to vaccinate your own population 3 times over? And that's sort of a discussion that's beyond sort of the legal framework. And so I think it will be very tricky at the WTO level for members to kind of sort of backtrack on what has been already agreed upon in the text, which is obviously rights and obligations and exceptions as well. But there has been some movement, for example, with the WHO, trying for technology transfer, those type of things, that maybe the WHO and other sort of also, WTO also sort of coming into the mix, some sort of a collective agreement of, willing parties, of course, that would make sure that, every country that needs certain things have got access to certain things.
Thanks, Kholo. I think Rafia has her hand. Yep.
Sorry, I just wanted to add to this, and I think I don't think I emphasized this enough, but the mRNA technology is owned by the American government through their National Institute on Health. So there's now more and more this pressure on them to look at how they license it to private pharmaceutical companies. So there's now this idea of really understanding that it is public monies that went to it. It is public scientists who work on this and all of those sort of things. So that's quite an important thing. The other one is that I think it's very important to realize to what extent activists cooperating across borders is really making a difference. I mean, with all of the things that are coming out, now we have a lot of papers coming out talking to pushing America to use what they call the Defense Production Act, and to almost force their companies then to share IP and know-how and trade secrets under that act, so the government can force them to share it with whomsoever they want, and to use that really to share it with low and middle income countries. And there's been, I think, we have moved running in IP in this time. And it's great because, and it's only, I think, really very much about the collaboration. I just wanted to emphasize those two things. Thank you.
Thanks, Rafia. Kholo, I see your hand is still up, but I suspect it is an old hand. Did you have something else to add, Kholo?
No, not at all. It's an old hand, so let me lower it. Sorry.
Okay. Very good. I think there's just one more question here that I want to allow the asker to pose, and then after that we can maybe wrap things up because I know we've run over a little bit. So, Chikosa Banda, do you want to ask your question? If you are still there.
Yes, I'm still here. I guess part of my question has been answered in passing, because my interest really was to understand the political economy of reforms in South Africa itself, because of this contradiction of action at a global level and then action at a domestic level. It would appear that the government of South Africa is pushing for reforms at the international level, but is very reluctant to implement reforms at domestic level. So I just wanted to understand what exactly is going on, because speaking from somebody from outside South Africa, it looks like there's that incoherence between what is happening at the domestic level and what is happening at the global level. Thank you.
Thank you very much. I think that's an excellent question. Caroline, do you want to have a stab at that one, maybe? I think you did speak to it a little bit in your presentation.
Yes, I did. And I was a little bit mischievous at the beginning by saying I wanted to hear Chikosa. So I'm very pleased that he has humored me and actually had the last word, so to speak, in this webinar. So Chikosa raises a really pertinent issue, something that personally bothers me. which I tried to articulate, this incoherence, this boldness and leadership and vision at international global level and continentally, and then this reticence that I can't actually quite understand at the national level. And so I don't really have an answer, safe to say that I've noticed the same thing. And I think that the country needs to move out of that, because the effect then of South Africa talking out of both sides of its mouth, once again, so to speak, is that it undermines its visionary leadership internationally, because the very next thing that is going to happen is other states are going to say, we're not going to listen to you because you're only agitating at this level, but you're stagnant at home. So actually, in order to support the global voice, I think South Africa does need strong action nationally, but I don't know why the country is in limbo at the moment.
Thanks, Caroline. I think that's probably a good place to end, or at least from my perspective it is. So thank you very much to all our speakers for taking the time and for your excellent presentations. We really appreciate it. For the members of the audience that have asked for the video recording and the slides, I am sure we will be sharing those in due course. So do keep a lookout for those. And for everyone who attended, thank you very much. It's been a really good webinar. We've all enjoyed it, I suspect. And yeah, I hope everyone takes care, and we'll see you for the rest of the series, hopefully.
Thank you.
Bye.
Thank you, Alex.
Thank you.